All right, good morning. Before we begin, let me remind everyone that we need to maintain social distancing to the best of our abilities. Unless you are a family unit or group, ask that you spread out in the courtroom, make use of the space. You can see that we have designated 6-foot areas on the back of the pews with orange tape. So if you're not a family unit, ask that you spread out and make use of that to prevent the spread of the COVID-19 virus. And before we get going, I want to talk about some of the logistics of today's hearing. I understand that each side may have some issues they want to bring to the court's attention before we begin. This is in cause number 19-00185, City of Canton versus New Beginnings Fellowship, Barney Joe Donaldson Jr., Covenant Community, New Beginnings Canton. I believe that we are set today on the city's emergency motion for contempt for violation of the court's temporary injunction rendered in January of this year. Before we go any further on that, I want to address the communication that Mr. Donaldson, and the record will reflect that Mr. Donaldson and Mr. Eisen are in the back of the courtroom. They have been placed there by the court staff and security. Mr. Donaldson, if you'll just stand where you're at, sir. And it's my understanding that you have indicated to the bailiff that you have been exposed to the COVID-19 virus. Is that correct, sir? Sir, have you been exposed? You have, okay. When were you exposed?
3-4 weeks ago.
3-4 weeks ago? Which one is it, 3 or 4?
I don't recall the exact date.
Where were you at when you were exposed, sir?
Homeless shelter which I was at.
Say that again.
The homeless shelter at which I was at.
And where is that, sir?
Houston, Texas.
And where is that, sir?
7135 Fulton, 11529.
And what's the name of that?
New Beginnings Fellowship Church.
So is it a church or a homeless shelter?
It's both.
It is both. Okay. And are you feeling symptomatic at this time?
All I have is a call.
Is that a yes or a no, sir?
No.
You're not feeling symptomatic. And you believe it's been 3 or 4 weeks since you have been exposed. And who exposed you? Do you know?
Resident Tara herself or now from placed on quarantine, testified that she was confined to a room at the facility.
Okay, and you've also indicated to court staff that Mr. Eisen has been exposed to the COVID-19. Is that correct?
That's what I was told.
And who told you that?
That's right.
Okay, and when did he tell you he was exposed?
At some point during the lockdown, I don't recall the exact date.
And when was the first time you brought this to the court's attention?
Several weeks ago.
When exactly, sir?
I have to go back to my email and find it. It was emailed to Mr. Parker.
Do you have that with you?
I have to go look. Yes.
Can you take a moment and look, please, sir? Maybe I'd highlight a couple of dates for you that you could look. April 2nd, May 14th, or this morning at 8:05.
May 14th.
May 14th. And what did you say exactly to Ms. Barker about your exposure to COVID-19?
I didn't say anything about that.
Okay, so when is the first time you indicated to the court staff that you've been exposed to COVID-19? Was it at 8:05 this morning? Okay, and why wouldn't you have indicated to the court previous to today, knowing that you've had notice of the setting? If you believe that you've been exposed to COVID, why would you wait until 55 minutes before the hearing to email court staff?
I assume that they were, I told about Eisen, I don't have, that's ex parte communications, I really didn't see any need to. I have.
You hang on. You said you didn't see any need to contact court staff about you being exposed to the COVID-19 virus before today, before today's hearing, after you've been on notice and actually have participated in online hearings? You haven't brought that to the court staff attention until today. Is that correct?
Yes, sir.
And you're asymptomatic and you believe it's been 3 or 4 weeks.
Yes, sir.
Please have a seat. Mr. Eisen, due to Mr. Donaldson indicating that he had been exposed to the COVID-19 virus this morning, the bailiff has indicated to me that you and Mr. Donaldson came into the building together. Is that correct? Okay, and that's the reason that you are also placed in the back so the court can determine whether or not you present a risk to those involved in this hearing today. Mr. Eisen, have you been exposed to the virus? And when do you believe you were exposed?
On March 9th.
Okay, and where?
March 9th in Harrison County.
March 9th in Harrison County. We're at in Harris County. And did you quarantine or were you tested subsequently?
I quarantined. I'll give you full details about it. I just want to answer the question about that.
You can just answer the question.
Okay. Quarantine, yes, I was quarantined. I'm not a quarantine.
You self-quarantined?
Yes, sir.
And did you get tested?
I did.
And what was the results of your test?
April 27th. That long test, I made the swab and came up negative.
So you were tested after your exposure and you tested negative. Are you feeling symptomatic today?
I'm feeling chest pain. I think there could be something happening. I also have another condition. So I can't prove that.
Were you at all concerned with Mr. Donaldson saying that he had been exposed to the COVID-19 virus and then you traveling with him or entering the building with him?
It was asymptomatic, so I don't have to let it run over here.
Do you have any concerns today that you may be carrying the virus?
I do not. I'm waiting for a blood test to see whether I have that virus or I have something else. I can't get an antibody test. It's been ever since Saturday in March, was the 16th. That's when I really started feeling symptoms, but that's a long time. So I don't think nothing.
All right, thank you, Mr. Eisen. Have a seat. All right, it's also my understanding that Mr. Voss is unable to join us this morning and may have had some kind of incident on the way to court. Is that correct?
That's correct. That's Mike Mark for the city of Canton. If I may, I'd like to recognize my co-counsel, David Ritter, who's spoken with Mr. Voss.
Good morning, Your Honor. I've not appeared formally in case my name is David Ritter, the assistant city attorney for the city of Canton and a partner of Mr. Voss's firm. He did have an accident on the way through Terrell this morning. One of the orange barrels was impacted by a semi truck and it kicked the base of the barrel up into his car. I was actually passing by at the time to go back and get his notes from him. His radiator was destroyed. He's physically okay, but he did not make it here this morning. Since he is the city's lead counsel and been prepared for this hearing, he is asking the court for a continuance. And that's also sort of heightened as well by the email that we got this morning from Mr. Donaldson, stating that he had been exposed to COVID and that he was experiencing some quote minor symptoms, I believe is what he said. So what Mr. Voss has asked me to ask for is the continuance, if possible, until later this afternoon, and possible via Zoom. He estimates that he could be prepared by about 2 o'clock. The last conversation I had shortly before the hearing started, and at that time he was on route back to Dallas in a record truck. So he's going to try to get a rental car and get either here, if that's the court's wish, or to location and conduct the hearing from. alternative, he's available anytime next week.
All right, thank you, sir. All right, Mr. Eisen, Mr. Donaldson, I know that you're in the back and it's a little difficult to hear. Let me repeat to the best of my ability what Mr. Ritter, on behalf of the city of Canton, has said, that Mr. Voss was involved in a car accident this morning. While he is physically okay, I believe, he's been unable to attend the hearing this morning. They've asked for a continuance. Can you not hear me, Mr. Eisen? I know, and I'm just repeating what he said to you. Mr. Voss has been involved in a car accident and is unable to attend court this morning, and he has asked for a continuance to this afternoon and possibly via Zoom as an alternative as well. If not, then he would be available anytime next week. The city of Canton has also indicated that they were concerned and also requesting the continuance based on Mr. Donaldson's allegation that he has been exposed to the COVID-19 virus. So at this time, there is an oral motion for continuance made by the city. Mr. Eisen, do you object?
My position on that would be you already have a hearing on June 1st.
I know, I'm saying, do you object to their request for continuance?
I don't object.
All right, that's fine. You don't object, Mr. Donaldson?
No, sir, Your Honor.
All right, that's fine. You can have a seat. You've answered my question. Go ahead.
Your Honor, I just received a text from Mr. Voss, leaving the rental car place in Richardson, heading to Canton, so he is en route.
Tell him just to hold what he's got. All right, so the court's going to take that into consideration. However, there are a few other logistical things that we need to cover. Mr. Donaldson, I believe that you are currently represented by court-appointed counsel in a contemporaneous criminal case, Mr. Kurt Knoll. Is that correct?
Yes, Your Honor.
And in this case, Mr. Donaldson, you are entitled to the appointment of counsel should the court find that you are in contempt of a court order, and if the court intends to place you in custody and deprive you of liberty, you would be entitled to court-appointed counsel if you are indigent. And I understand that you've already been found to be indigent, and court-appointed counsel has been provided to you in that criminal case. Would you like court-appointed counsel in this case? You have that right, or you can waive that.
Do I have yes, I am entitled to counsel, yes.
I know that you are, because I've told you that you are, because that's what the law says. I want to know, do you want court-appointed counsel in this contempt case?
Yes, Your Honor.
You do. Okay. Then the court is going to appoint the Honorable Kurt Knoll, who is the attorney who is representing you in the criminal case, to represent you for this motion on contempt. Okay. The court is going to continue this hearing and give no less than 10 days preparation to Mr. Knoll to prepare for this hearing. And we'll discuss that in just a moment. So court is going to grant a continuance. Mr. Ritter, you can let Mr. Voss know that he does not have to appear today, and I'll give you that date in just a moment. You can have a seat, Mr. Donaldson. Mr. Ritter, I understand that in the city's motion for contempt, there's also other parties who have been identified. Is that correct?
That's correct, Your Honor. There have been other parties identified as associates or in concert with the court defendants. In addition, a new amended petition has been filed that certain parties have not been served.
Who has not been served?
I believe the new additional parties are the Chapman defendants. Mr. Chapman, both through the Chapman Eustace organization, and Mr. Chapman and his wife individually, the Arise Church entity, and both of the harbors, harbor associated with that entity. That may be looking at those petitions.
So you believe it's all of the additional parties that have been identified in the motion for contempt?
I believe so, and you can as well. And none of those parties have been served, but I believe the petition was just filed.
All right, is Mr. or Miss Chapman here? Donna Vega? Is Donna Vega here? Is Jamie Harbor here? Is Dean Harbor here? Is Arise Church here? Mr. Ritter, is it the city's intent to ask the court to hold Jamie Harbor, Dean Harbor, Kevin Chapman, Donna Vega, Chapman House Eustace, and Arise Church of Canton in contempt in conjunction with the emergency motion for contempt?
Yes, Your Honor, all those parties were named as acting in concert with or as a successor entity in various capacities to the what we call the board that is already served in the case.
All right, Ms. Harbor, Mr. Harbor, if you will stand, please. What I'd like to do at this time is go ahead and advise you that if you are found to be in contempt of the court's order by proof given at the next hearing, that you would be entitled to the appointment of counsel if you are indigent. Do you believe that you are indigent, meaning that you are unable to financially employ counsel, Ms. Harbor? Right, do you believe that you are indigent and financially unable to employ counsel?
Yes.
Okay. Bailiff, if you will. Ms. Harbor, I'm going to have the bailiff hand to you an affidavit of indigency. I'm going to need you to fill that out and give it back to the bailiff. Mr. Harbor, do you believe that you would be indigent for the purposes of appointment of counsel? All right, Mr. Harbor, are you and Ms. Harbor in the same family unit? All right, then you can approach the council table here and have a seat. And we're going to take a moment. Bailiff, if you'll give this to Mr. Harbor. Provide him a pen. While the Harbors are completing some paperwork for the court, let me ask Mr. Eisen, Mr. Donaldson, Mr. Ritter, the court would look to reset this to Friday, June 12th. Can you check your schedules at this time and tell me if you would have any conflicts? Yes, sir. Yeah, the court's going to cancel that because that would be less than 10 days preparation from Mr. Donaldson's attorney. So we'd be looking at June 12th. Thank you, sir. Well, let's do this then. Let's you request with my coordinator a setting on your motion to withdraw. Have you already filed it?
I am not.
Okay, once you file it, then contact my coordinator and we'll set it, and we can do that by Zoom. We can do that as an online hearing and have all parties involved.
Your Honor, I believe the 12 works for Mr. Voss and for others.
Okay, let's go ahead and plan on that. Mr. Donaldson?
I would request that if the Harrison County remains under continued stay on board that the hearing be conducted by Zoom as a board of commissioners. That's supposed to be the county now that there are.
I understand.
We have to speak.
Not right now, Mr. Donaldson. I'm taking up another issue at this time. I'm waiting on the harbors. sir. Ms. Harbor, I've got a question. Based on the financials that you provided, it appears that your monthly expenses exceed your income every month by over $1,300. Is that right? Okay. All right, then the court is going to find that LSD Harbor and Jamie Lynn Harbor are indigent, financially unable to employ counsel. The court hereby is advising each one of you that you do have the right to have an attorney appointed for you if found to be indigent. The court has found you to be indigent, and I understand that based on your documentation here, you are requesting the court to appoint each of you counsel in this contempt hearing. Is that correct? Ms. Harbor? Mr. Harbor? Okay. All right, then the court will make appointments of attorneys and provide you that information before you leave court this day. All right, before we come back on June 12th, I want to go over what the court's expectations of the hearing are on June 12th. On June 12th, the court will allow the city to present its motion for contempt and the evidence that's offered thereon by both the city and then any defense or mitigation offered by the defendants in the case. The court, in conducting the hearing, will be looking at whether or not there has been compliance with the court's temporary injunction, which was signed and filed by the court on June 24th, 2020. And I want to take a moment, I want to go over everything that's in that order so that if things are existing today that are in violation of this order, they can be corrected before June 12th. Says that it is ordered that the defendants, and the defendants at this time are New Beginnings Fellowship Church of Houston, Texas, and Barney Joe Donaldson Jr., Covenant Community of New Beginnings Fellowship, Canton, that the defendants, including their employees, their servants, their contractors, their volunteers, their successors, their assignees, and any persons in active concert or active participation with defendants, and all other persons who are occupying the property are enjoined from occupying the property in any manner, including as a residence, and are enjoined from maintaining the property in violation of the City of Canton ordinances laid out in City Code Title 15, Land Usage, Chapter 150, Codes Adopted. Court has also ordered that the parties shall, specifically the defendants, shall remove all personal property from the subject property, save and except for any personal property that's being stored inside of the building. The court has enjoined anyone from entering the property for any reason except upon permission by the court and pursuant to this temporary injunction until the defendants provide evidence to the court of defendants' compliance with the city's commercial plan submittal guides for all work, including remodel, renovation, all work that defendants intend to perform on the property. Defendants are prohibited from performing any work on the property until defendants obtain any and all required permits from the city after compliance with the requirements I stated previously. Defendants are prohibited from allowing any and all persons from residing in the property for any period of time, and in any event, all such residing persons shall vacate the property. The property shall remain vacant of all persons until the defendants obtain a certificate of occupancy from the property from the city, except as provided in this temporary injunction. Defendants shall post this temporary injunction order on each entrance to the property, shall post signs in conformance with the city's International Property Maintenance Code, giving the public notice that the property is vacated and that entry is prohibited, and shall provide a copy of this temporary injunction to all persons residing in the property. It is ordered in this injunction that the City of Canton Police Department personnel and or the Van Zandt County Sheriff's Department personnel shall monitor the property and are authorized to enter the property to determine if anyone is trespassing upon the property in violation of this temporary injunction, and to determine that the other terms of this temporary injunction are being complied with. It was ordered by this court in January that the defendants are prohibited from selling, transferring, or otherwise conveying any interest in the property without obtaining prior permission of the court. And to my knowledge, this court has not approved or authorized a sale, a transfer, or any other conveyance in the property. So I want to be clear that the court has issued this temporary injunction on January 24th, and the court believes that the injunction and the orders therein are clear and can be complied with. When we come back on June 12th, the court's going to hear evidence as alleged in the motion. If the court finds that this injunction has been violated by any corporate business entity or any individual, then the court is going to apply all remedies that it has, including civil, indirect, or coercive contempt or criminal contempt. That means if any individual is in violation of this injunction and continues to be in contempt of the injunction, then that individual should be prepared to go to jail on June 12th. If anyone who is served in this action to appear on June 12th and receives notice and does not appear, then the court will issue a writ of attachment to have you picked up by law enforcement and brought before the court to answer as to whether or not you should be held in contempt for violating the temporary injunction. I want to make it very clear what lies ahead on June 12th. I don't want any excuses as we came in and we don't have a copy of the injunction. No one has served it upon us. This is on file at the Van Zandt County District Clerk's office. You can walk across the hallway and get a copy of it. And it's been provided to every party in this case. So I don't want any excuses as to we didn't know what was in there. No one's advised us of it. We don't know where to get it. You know where to get it now. And the court expects strict compliance. The court has given each party the opportunity to present evidence as to whether or not this is a health and safety code violation, a fire code violation, and the court has found that it is. And that in order to rectify that, the building has to be brought up to code in compliance with the laws and in compliance with this temporary injunction, which requires a certificate of occupancy before people can reside in or on the property. Being on that property and not in compliance with this injunction is going to constitute trespassing, which is a criminal offense, which is going to subject you to arrest. Mr. Donaldson, you had a question or wanted to say something earlier? Go ahead, sir.
I have two issues.
And let me say, before you proceed, the court has appointed you counsel for the contempt proceeding, Mr. Kurt Knoll. I would recommend that you not make any statements that could be used against you in this proceeding without first speaking with your attorney. Is it regarding the setting? Is it regarding logistics? Or is it regarding this contempt hearing?
It will, unlike Mr. Russ, I don't remember his name now, will unlikely be my counsel at the next hearing and make some statements made previously. But now he is my attorney.
Mr. Who?
I don't remember Kurt, someone in Tyler.
You don't know your attorney's name who's representing you on the criminal case?
We talked one time and he disrespectfully called me boy and I hung up.
His name is Kurt Knoll, Knoell, Knoell. And the court has appointed him to represent you because you requested court-appointed counsel in the criminal case and here in this contempt case. Go ahead.
Two issues. One, at the last court hearing, the status conference, I personally asked the court, made a motion for permission to enter the property, to remove property, because our property. I advised the court that on December 30th, the property was transferred. That was before your injunction was entered. Documents were filed with the court, they were given prior counsel or wherever. They didn't object to these transfers at that time. Court granted me permission to go in the building and retrieve the property belonging to New Beginnings to take it to Houston. I was making trips back and forth, and the COVID virus stopped before I could complete. I don't intend, because of the stay-at-home order, I don't intend to start making trips back and forth again, but I would ask, since I'm physically present, I have a truck, may I go to the property day to get some more of our property before it gets stolen by others.
I believe the court's already granted you that, Mr. Donaldson.
You granted a 30-day window, and that window expired. The COVID virus prevented you from coming back in that 30-day window.
City, have any response on that?
No objection to the limited ability to remove personal property. As long as no one is staying there or any other terms of the injunction are violated.
Thank you, Mr. Ritter. Mr. Donaldson, how long will it take you, do you believe, to remove any property that's remaining in that facility?
I would probably have to make 20 to 30 trips with my truck to get all of our property. I cannot physically do that in my house. I made before the COVID virus broke out, I made 3 trips, 2 on one day and back and forth from 1 on the second day. So I really, get what's valuable today and then the rest of it with the new owner, whenever they take possession or can get access, I can get it from them.
All right, then, Mr. Donaldson, the court is going to, as it has before and has always been willing to, is going to grant you the ability to enter into that facility to retrieve any remaining personal property. Personal property. In order to do that, you're going to need to, the court's going to grant that conditionally upon each time that you want to enter into that facility. You must contact the Canton Police Department and let them know the date of your arrival and the anticipated time that you're going to be there, so that the city of Canton will be aware that you're there and what your purpose is, so that they can continue to enforce the temporary injunction as they have been legally obligated to do. So you'll need to contact them, tell them when you're arriving and the purpose that you're arriving for, so that they can monitor that if they so choose.
Is today permissible before we go back to Houston?
Today is permissible. I believe that there's members of the Canton Police Department that are in the gallery. And so they're on notice that you are here today and that you've requested permission to enter the facility and that the court has granted you that. So yes, today is permissible.
The other issue is simply the order requires us to post a sign that entry is prohibited in the building. I posted the sign, I provided the court with documentation, a picture of the sign posted, they agree that sign posted. I am not physically here in Canton, I can't keep people from tearing down the sign. It is my intention to make another sign on a piece of poster board today and put it up. But it's, I asked the court to understand, I'm not physically here, I don't live here anymore. I have no need to come here except for court. I don't have the financial resources to be traveling back and forth again. So I just asked the court to acknowledge I'm going to place another sign up there today. And that I have no control over what they do.
I understand, Mr. Donaldson, you are a party in this suit and you have been enjoined and you have been ordered by the court to ensure that that building remains locked up and that all signs remain posted. So whether you're in Houston or Canton or anywhere else, it's your responsibility to ensure that this order is complied with. Your failure to do so could result in you being found in contempt. So if you get notified by anyone that the notice is no longer posted, then you need to make arrangements to make sure that it is posted.
One final thing, and this may not even be relevant to me since we don't order. The order prohibits us from entering the property for any reason, yet requires us to comply with city codes. We kept getting complaints from the neighbors. The property, the grass was growing out of control. And I believe that someone that's living on the property borrowed a lawnmower and cut the grass. The orders require the grass to be cut. The orders require that the building be maintained. How do we do that if we're not allowed to property?
Say that again, Mr. Donaldson.
The ordinances that were ordered to comply with require that the building be maintained, that the building be kept secure, that the grass be cut. How do we do that if we're prohibited from being on property for any reason?
I believe the order is pretty clear. Have you read the order?
Yes, I have.
And where do you think it's unclear? Does it not make a provision available to you that you're able to enter in onto the property as long as you are in compliance with the city codes? We're talking about repair of the property. We're talking about inside. We're talking about painting, drywall, construction, roofing, window. That's what we're talking about.
Work being done on the property, it's not aware, as long as it's been done in the city report in the way that the police report says people are on the property, one of them specifically says that they were cutting grass in violation of the code.
On page 3, the order, I'm going to read it again. It is therefore ordered that the defendants, including their employees, servants, contractors, volunteers, successors, assignees, and any persons in active concert or active participation with defendants and all other persons who are occupying the property are enjoined from occupying the property in any manner, including as a resident, and are enjoined from maintaining the property in violation of the following codes. In violation of the codes. So mowing the grass, is that going to violate a city code? Defendants are prohibited from performing any work on the property until the defendants obtain any and all required permits from the city after compliance with those previous codes.
So I'm still not quite clear. We can maintain the property if necessary. It's difficult for me to wrap my head around this language here.
Mr. Donaldson, I find that very hard to believe that you can't wrap your mind around this legal language considering the numerous motions and pleadings you have filed. You're not feigning ignorance with the court, are you? You're not trying, but you are, Mr. Donaldson. So,
Yes.
okay, we're gonna take a moment. Will you get Ms. Harbor and tell her she needs to be back in this courtroom? We're going to stand in recess for 10 minutes. Mr. Harbor, do you want to go check on your wife? All right, we're going to stand in recess for 10 minutes. We'll resume at 25 after. Please maintain social distancing as you move around the building. Make sure if you go in and out of the restrooms that you're acknowledging anyone who may be in there. Give them their space, okay?
Okay.
Yeah. That is our, state of home.
All right. All right, please be seated. All right, we're back on the record. Ms. Harbor, I would appreciate it if you would not get up and storm out of the courtroom while we were trying to have a discussion about the case. Okay? Can we handle that? Can we do that? Thank you. Mr. Donaldson, we were discussing whether or not you understood the language in the order.
Your Honor, after, during the recess, I was looking at it, temporary restraining order, temporary injunction, and considered your stress on the word occupy. I Googled the word occupy, it says reside or have one's place of business in a building. I Googled occupancy permit, it's a certificate issued by a local government agency certifying that a building complies with applicable laws and is suitable for occupancy. Based on the court's order and these definitions, it's my understanding that the order simply prohibits use of that place for one residence or business. It doesn't prohibit any other access to the property, such as maintaining the grass, cutting, painting, or any work that doesn't require actual
I'm not going to give you legal advice, Mr. Donaldson. You've chosen to represent yourself in this case without an attorney, and so you can make the interpretations that you want. All I can do is give you the order.
I'm asking for clarification. It's my understanding that the court has been answering the police department's orders for clarification. Police department has contacted you asking for clarification who this order applies to, and whatnot. I'm simply asking.
And Mr. Donaldson, let me correct the record right there. The police department contacts me and asks me, is this order still in effect? There's no clarification. There's no discussion. We're not having coffee. We're not changing the order. We're not clarifying the order, Mr. Donaldson. They enforce the order and they ask before they try to enforce it. They call and they say, is there a new order? Is there any other order, Judge? No, this is the order. Thank you very much. Okay, so the record's correct on that now. So go ahead.
The city has filed a video of the police officer stating that they contacted you and that you told them the order is still in effect and that it applies to all people on the property and that the order is against the building, not the individual. That's the exact quote.
Mr. Donaldson, are we going to have a hearing on the motion for contempt?
No.
Because we can. If you want to waive counsel and we want to go forward today, we certainly can do that. You told me at the outset of this hearing, when I advised you of your right to have counsel appointed to you because of the possible confinement of up to 6 months in jail and a $500 fine, you told me you wanted counsel, and I've appointed counsel for you. I'm going to effect that order as soon as the hearing's over. Sounds like now you're wanting to waive counsel and you're wanting to make an argument today on their motion for contempt and what's included therein. Am I correct?
I'm not wanting to do that.
Okay, then let's don't be discussing that anymore. We're discussing the order, and I have told you what the court's position on the order is. Do you see anything in this order that prevents you from mowing the grass?
No, sir.
Then what's the problem?
No problem.
Okay, anything else? Ms. Harbor, you may have a seat. Ms. Harbor, before while Mr. Donaldson was talking, you kept raising your hand. Do you have a question?
Well, you asked the question I was going to ask, and you started repeating what you have read. Because my understanding and how you worded that, it states that we're not even allowed property nor maintained. And the word that,
And that's not what's in the order at all, Ms. Harbor.
sir,
That's not what's in the order at all.
that's what it says.
Let's read what it says. I'm going to read it. We're going to read it on the record so that everyone can hear. I'm going to start at the beginning. On January 22nd, 2020, came on to be heard plaintiff, City of Canton's verified application for temporary injunction. Messrs. Edwin P. Voss Jr. and Michael L. Martin, attorneys for the plaintiff, City of Canton, Texas, appeared in person. Defendants, New Beginnings Fellowship Church of Houston, Texas, and Covenant Community of New Beginnings Fellowship Canton appeared through counsel, and defendant, Barney Joe Donaldson Jr., appeared personally. The City of Canton, plaintiff in this cause, has filed a verified petition for temporary and permanent injunction with supporting affidavit and documents as set forth in plaintiff City of Canton's original petition and verified application for temporary restraining order, temporary and permanent injunctive relief, declaratory judgment, and civil penalties. After hearing the city's request for temporary restraining order and considering the evidence presented by the parties at said hearing on January 8th, 2020, the court granted the city's request for a temporary restraining order on January 14th, 2020, a copy of which is attached hereto as Exhibit A. The city requested the court to take judicial notice of the testimony and admitted evidence presented at the hearing on the city's request for a temporary restraining order on January 8th, 2020. The court granted the city's request and takes judicial notice of all testimony and admitted evidence from the January 8th, 2020 hearing in this matter. It appears from the facts set forth in the city's petition and at the hearings conducted on the city's request for a temporary restraining order and temporary injunction that defendants are knowingly owning and operating a purported residential condominium complex at the commercial property located at 901 West College Street /673 West College Street in Canton, Texas, and legally described as a 4.808 acre tract of land situated in the Heritage Manor addition to the city of Canton. I'm going to skip down to the next, in unlawful manner and in violation of city ordinances and regulations. Next paragraph. Specifically, the violations at the property include the following. The zoning classification on the property does not allow for the residential use of the property. The property does not have a certificate of occupancy issued from the city for it to be occupied in any capacity. The property lacks adequate and code compliant electrical systems and service, instead using other electricity sources such as a temporary solar panel system connected to the building's wiring with extension cords. And 4, the property contains numerous other serious health and safety code violations. The property's physical conditions violate the following code ordinances, including but not limited to City Code Title 15 Land Usage, Chapter 150 Codes Adopted, Section 150.16, and City Code Title 15 Land Usage, Chapter 151 Buildings, 151.01, 151.02, 151.03, 151.04, 151.05, 151.06, and 151.07 by maintaining unhealthful and dangerous conditions on the property as established by the evidence. As such, the property is a public nuisance under the above referenced City Code of Ordinance provisions because the conditions that exist on the property do not comply with applicable city building and property maintenance codes. Defendants have repeatedly notified by defendants have been repeatedly notified by the city of these and other serious health and safety problems at the property. Defendants have failed and refused to remedy these numerous health and safety issues, have installed non-code compliant workarounds, and continue to occupy and maintain an unsafe, unhealthy, and dangerous building on the property, notwithstanding the requirements of the court's temporary restraining order dated January 14th, 2020. The evidence presented to the court establishes that defendants' activity at the property exemplifies these serious problems and establishes that more people, furniture, and fixtures are moving into and occupying the substandard building on the property as a residence. The city's efforts to obtain compliance with its ordinances and codes that provide for the health, safety, and welfare of the citizens of and visitors to the city of Canton have been thwarted by defendants. The city's petition and the evidence presented to the court establish that defendants intend to continue to occupy and to use the property and building that are unfit, dangerous, and lack basic health and safety requirements in violation of city ordinances and of the temporary restraining order issued in this case. The city's petition and the evidence before the court established the city's entitlement to immediate relief under subchapter B of chapter 54 of the Texas Local Government Code and the Texas Rules of Civil Procedure. The city has established a probable right of recovery and probable injury supporting issuance of a temporary injunction against defendants. It is therefore ordered that defendants, including their employees, servants, contractors, volunteers, successors, assignees, and any persons in active concert or active participation with defendants and all other persons who are occupying the property are enjoined from occupying the property in any manner, including as a residence, and are enjoined from maintaining the property in violation of the following city codes. And I'm not going to read those for time. It is further ordered that defendants, including their employees, servants, contractors, volunteers, successors, assignees, and any persons in active concert or active participation with defendants and all other persons who are occupying the property shall immediately do the following to address and remedy the city ordinance and health and safety regulation violations that exist on the property. Subsection 1, defendant shall, by no later than 5 p.m. Central Standard Time, February 3rd, 2020, vacate the building on the property of all persons and prevent anyone from entering the property for any reason, except upon permission of the court and pursuant to this temporary injunction, and not until after the defendants provide evidence to the court of defendant's compliance with the city's commercial plans, submittal guidelines for remodel, renovation, which inter alia include submitting a complete set of construction plans indicating work that has been completed since the time the defendants purchased the property and all work defendants intend to perform on the property from this point forward, as well as submit a complete asbestos survey to the city in accordance with the Texas Asbestos Health Protection Rules and the national emission standards. Subdivision 2, defendant shall be permitted to store personal property inside the building on the property, understanding that such storage shall be at the sole risk of the defendants and provided that the personal property is not stored in a manner that creates a hazardous condition or poses a threat to public health, safety, and welfare as determined by the city in its sole discretion, and said personal property shall not be stored in a manner that inhibits the city's inspection of the property set forth in subparagraph 9 below. Subparagraph 3, defendants are immediately prohibited from performing any work on the property until defendants obtain any and all required permits from the city after compliance with the requirements of subparagraph 1 above. Defendants shall immediately prohibit any and all persons from residing in the property for any period of time, and in any event, all such residing persons shall vacate the property by the deadline stated in subparagraph 1 above, and the property shall remain vacant of all persons until the defendants obtain a certificate of occupancy for the property from the city, except as set forth in this temporary injunction. Subparagraph 5, defendants shall post this temporary injunction on each entrance to the property, shall post signs in conformance with the city's adopted International Property Maintenance Code, giving the public notice that the property is vacated and that entry is prohibited, and shall provide a copy of this temporary injunction to all persons residing in the property. Subparagraph 6, defendants shall, within 12 hours of the deadline for vacating the property described or discussed in paragraph 1 above, secure each entrance to or exit from the property with a fence or lock, and give at least one key or other access device to the City of Canton Police Department and the Van Zandt County Sheriff's Office. Subparagraph 7, City of Canton Police Department personnel and or Van Zandt County Sheriff's Department personnel shall monitor and are authorized to enter the property to determine if anyone is trespassing upon the property in violation of this temporary injunction, and to determine that the other terms of this temporary injunction are being complied with. Subparagraph 8, the City of Canton shall prohibit the reconnection of water service to the property that was disconnected pursuant to the terms of the court's temporary restraining order without prior written direction from the court. The city may reconnect all public utilities necessary for the purpose of conducting the inspections as set forth in subparagraph 9 below. Subparagraph 9, I'm not going to read that. You may read that for yourselves. Subparagraph 10, defendant shall drain all rooftop water storage tanks of all water by no later than 12 hours prior to the start of the scheduled third-party inspection described in subparagraph 9. Subparagraph 11 relates to having representatives available for subparagraph 9, not at issue in this hearing. Subparagraph 12 is that the organization appointed to complete the inspections to submit a report. It is further ordered that defendants are prohibited from selling, transferring, or otherwise conveying an interest in the property without obtaining permission of the court. So, Ms. Harbor, what is it that is specifically confusing to you?
Can you read that, the last two sentences again? I didn't hear it.
The last two, it is further ordered that defendants are prohibited from selling, transferring, or
One before that.
the one before that? The sentence before that?
Yes.
Subparagraph 12, Bureau Veritas shall provide a written report to the city within 3 days of completing its inspection, and the city shall file a copy of Bureau Veritas's report with the court within 24 hours of receipt, with service to be provided to the defendants. That's the sentence before that. I didn't read that paragraph. I didn't read that one because it wasn't at issue.
Well, the report was given that everything was intact, was it not? That's what I thought you were reading all along, with what happened at the final hearing.
No, I told you what I was reading. I told you I was reading the temporary injunction, which is the order of this court, which is what we've been discussing, that Mr. Donaldson says is unclear and you say is unclear. And so I'm saying what's unclear about the court's temporary injunction?
My impression is that is no longer valid, that was completed on the day that Bureau Veritas submitted, and they came back on January or February 21st. And that it was clarifying exactly that the New Beginnings Fellowship in Joe Donaldson get his possession, that Bureau Veritas report was made, and that the building was able to be occupied and safe. We were just needing to do those things, to get a ground rock, if the power was deemed safe, all those things. That is what I have not been able to gain possession of. And so therefore, we're all interpreting what was stated on the February 21st, our own interpretation. And so where's that is what I'm saying. There's no grounds. I understand all of those things. But there was another order made, was there not, on February 21st, from the report being made? Was there not a final notice and a final ruling for this injunction?
City, do you have a copy of any?
Your Honor, I don't have any indication that there's a written order modifying the temporary injunction. It certainly hasn't been the city's understanding.
Yeah, just to my knowledge, Ms. Harbor, this is the only injunction that the court has ordered.
Right, but on February 21st, they gathered again on that Friday.
And the court issued no modification of this injunction, which maintains throughout the pendency of this case until the case is resolved.
As me, even as a public record, I understand what that is, but there were things stated in that court date that in order for me to inquire would be the transcript. So how is that, and including, so how am I to know exactly what was to be maintained as a representative of a different entity? And then also that they are doing their job appropriately as well, that we're all abiding by it. Because I understand those things, but there were more things stated from you on February 21st that are not public, that I can make sure that I am, and that they are doing their job as well.
Give me an example.
Well, exactly that, going to a private property that has been purchased and has been paid for.
You're saying that I discussed this in the February hearing?
No, you're saying give an example. So you're saying give an example of on February.
No, I'm saying give me an example of what you said that I authorized or changed about this injunction in February. You said that things were discussed, and I said things that were not public.
There was two things in there that you were reading about the report. The person, from what I had heard, the persons who were going to be continuing the property, owners, whoever that may be. There was some sentence in that prior to that, I don't know if it was that section 12 and all that. That you said they had the permission to go on the property to do what was requested and pull permits.
Subparagraph 9 says that a third-party inspection of the property shall be performed by Bureau Veritas, and that was done. And they appeared, and the city proved compliance with the order. The witnesses testified, court took their testimony, were cross-examined by Mr. Eisen. cross-examined by Mr. Donaldson. That did occur in February. And so they complied with, the city complied with Bureau Veritas complied with subparagraph 9 and 12, to my knowledge.
Right, and was it, their report showed that the building is safe to occupy?
I don't believe their report did show that. And I don't believe that was the testimony before the court.
And so where's that public record?
Where is that public record? You mean, where's the testimony?
Of the report of the Bureau of Veritas, and their report made.
It was,
Your statements regarding.
that was required to be reported to the parties, and Mr. Eisen has a copy and Mr. Donaldson has a copy. Were you not provided a copy of that? And were you not an employee of New Beginnings at that time?
I've been a volunteer there.
Okay, well, I mean, you were a volunteer there. So you would fall under the purview of this injunction as a volunteer for New Beginnings. Mr. Donaldson had a copy of the Bureau Veritas, as did Mr. Eisen, because that
Right,
was,
but what was your statement? The only, any other hearing that has been made, and if anything stated or changed, you always send out something, which I have. But there's something missing, is what I'm saying. Because if it's not clear onto where anyone stands. So we're damned if we do or don't, is what this is saying, and that we're to completely surrender the property for them to just take it. I'm not understanding that, because if the property is wanted that bad, then they should rightfully purchase the property.
well, and let's do this, Ms. Harvard. We're set today on a motion for the contempt.
Right.
Okay, and that's it. I really don't mind trying to clarify how to get in compliance with the court's order, because I don't want to be in a contempt hearing. I don't want to be receiving evidence of violation of an order and be put into a position that I have to determine, does someone get fined, or does someone go to jail, or someone gets both. I don't want to have to do that. I will, because I'm required to do that, and that's my oath. However, I would rather that not be the issue. And that's what's before the court today. So I don't mind clarifying, but if we're going to get into your interpretation of the law, and you're not represented in this case other than for the motion for contempt, then that's another hearing for another day.
My question is how do I know, and where are those? Because the February 21st is not on public record. There's nothing from that day. So how am I to know what was different, what was established?
Let me get Mr. Donaldson first, because he stood up first, Mr. Eisen, and then I'll recognize you, sir. Go ahead, Mr. Donaldson.
Your Honor, I believe what she's referring to is not the injunction, but the status conference. At the end of it, I asked, we went through the Bureau of Veritas reports, and there was minor electrical problems that needed to be fixed. At the same time, I asked about, when we could get we're not the owner anymore, get our property. I asked, can the new owner go on the property, can the new owner full permits and proceed from there, and that's your answer was yes, permit. That's what I believe she's talking about.
I would agree with you, Mr. Donaldson. That did occur at the end of that hearing. You did inquire about getting personal property, and if you could, someone else could maintain the property and begin. And I said, yes, in compliance with the temporary injunction, which requires going to the city, getting the permits, submitting the guides, the same thing that you would have done if you were not involved in a lawsuit. The same thing that anyone who creates a commercial building here in the city of Canton has to comply with. Go to the city, get the permits, submit the guidelines, get approval, get authorization to work, and then to begin the work. So I believe that was my intimation at the end of that hearing, was that this does not prevent you from getting the building up to code. It does not prevent you from doing that. And I believe that the issue that Mr. Donaldson stated at that time was maybe not the end of the hearing, but throughout these hearings, was we just don't have the money to do that. We don't have the money to submit engineered drawings, architectural drawings, and to have an overhaul. And that seemed to be an issue of, why can't we just do it ourselves, which resulted in, because it's not in compliance with the law. And so at the end of that hearing, my indication was, yes, you can absolutely go onto the property and maintain it and get a certificate of occupancy. You can do everything that you could do before the lawsuit started, save and except now you have to comply with this injunction, which means you have to do those things. If not, you could be found in contempt of a court order. Does that make sense, Ms. Harbor?
Yes, but.
So this is the controlling document here, to my knowledge. I don't believe that there is any other order from the court.
That would certainly be the city's position, and the city, there's been numerous, I think 5 or 6 times where the city has laid out the roadmap, literally with a checklist for what needs to be done in order to achieve a certificate of occupancy. There's literally a roadmap that's been provided as early as April of 2018.
And Mr. Ritter, do you know who it was provided to?
I personally emailed it to Mr. Donaldson back in April of 2018, and I believe Mr. Clark, either directly or through other city employees, has provided it over the counter at least 3 or 4 other times.
What about to Ms. Harbor? Have you provided it to Ms. Harbor?
I don't know if Ms. Harbor has been provided that specifically. We can certainly.
Would you be willing to do that?
Absolutely.
Provide that to her? All right, so before we leave, Ms. Harbor, let's make sure that we get your email address or mailing address or both. So, yes, Mr. Harbor.
If I may say, from day one, since my wife and I stepped in the building.
Well, let's not get into facts.
Yes, sir.
Let's not get into anything that is going to come out in a contempt hearing.
Yes, sir. I personally wanted to comply. So we will further this as of later to full permits. One of the things that we are in violation for right now is people being on the property, and I do understand that. Yes, we allow them to be on the property, and I know I'm saying that, and I'm saying that I did that.
And I want to caution you, Mr. Harbor, you shouldn't say that. You shouldn't say that because you've requested counsel and we've reset this hearing. This is on the record. Okay. So before you go any further, you can incriminate yourself here by the statement you just made, and you need to be cautioned on that. Okay. So you have the right to have an attorney represent you because you've been found indigent, and the court at the conclusion of this hearing is going to appoint you an attorney. So I want you to be aware that you shouldn't say anything at this point. That would be my guidance to you. I can't advise you, but that'd be my guidance to you, is that the court has appointed counsel for you, and you should wait and speak with your counsel, and then let your counsel make the arguments and have any negotiations with the city along those lines. So I would rather you not admit to anything without talking to your counsel first. Now, I can't prevent you from doing that. If you want to do that, you certainly have the right to waive counsel and to do that. But in order for me to allow you to do that, I would have to be sure that you are intelligently, knowingly, and voluntarily waiving that counsel, and that you're admonished of that, and it's of your own free will, and that you appreciate and understand the consequences that could flow therefrom. Okay. And so I'm not there yet. I haven't heard anything from you about wanting to waive counsel. So you've been admonished of that. So are you wanting to waive counsel at this time? What my recommendation would be is that if there is any clarification needed about the order, that if you have a very specific question as to what the court's opinion of that order is, I can address that for you. And I've tried to do that today, that you can maintain the property, you can go on there, you can improve, so long as you comply with this. And you need to have a copy of this, and you need to make sure that you comply with it, so that you are not in contempt, so that you're not violating the court order. And this says you've got to go to the city, you've got to pull permits, it has to be approved before anything happens. That doesn't mean you can go in there and start painting. That doesn't mean you can't go in there for any work whatsoever without going to the city first. Okay. So I'm trying to clarify that because, as I said, I want I want everyone to be in compliance with the order. I want the city of Canton to comply. I want New Beginnings Houston. I want New Beginnings Canton. I want Mr. Donaldson. I want any employee or volunteer or anyone else associated with it to be in compliance, because the simple remedy is comply with the law, just like every other commercial building in Canton, and you can get to where you want to go. You can get to where you want to go. Will it take more work? Will it take more effort? Will it take more money? Perhaps. The same thing that every other commercial building in the city of Canton has to do. You have to accept the same thing when you take an undertaking like this. So it doesn't say that you're damned if you do, you're damned if you don't. It says that, yes, let's go through the law, let's get our compliance, let's get our certificate of occupancy, and then you can build it up. And whenever you get that occupancy, when you get the permits and you get compliance with the law, and then your building is up and going, then you can occupy it to the extent of the permit allows you, and you can conduct your services. You can conduct anything that you're allowed to within the law. Okay, so it's not a damned if you do, damned if you don't, just let them take it. That is not what the court's order says. And I don't want anyone to misconceive what it says. And if you don't know what it says, then maybe you should hire an attorney and ask an attorney. Maybe you should call the city of Canton's attorneys, discuss it with them. I don't believe that they're trying to prevent you from bringing about a church or a rehabilitation facility or anything else. There's no evidence before the court of that fact. In fact, the exact opposite of what I've heard from the city of Canton and its attorneys. Okay, Ms. Harper?
But the law does not state there is a timeline for those things to be acquired, correct? When you purchase the property, you can do as you wish, quote unquote, maintain. But when it comes to, and knowing what the city's requirement, the law states for commercial, residential, whatever, there's not a timeline attached when I can purchase it and let it sit. But when we do go in to do those things, we are required to follow the law, correct?
Correct.
Okay, so we have not been working, we have been compliant with that. When we arrive to the property.
Okay, all right, so I'm gonna caution you the same way I cautioned Mr. Harper. Okay, so it sounds like you're about to get onto a narrative about when we arrive, this is what we've done, this is what we haven't done. You need to be admonished the same thing that he has. You've asked for counsel, and I've appointed counsel for you, and it's really the court's guidance that you not engage here on the record with this court regarding what you've done and what you haven't done until you've spoken with your attorney, because you may incriminate yourself. And at the end of the motion, the city's emergency motion for contempt, if it's deemed that the court has jurisdiction over you and that you have violated the order, then it's possible that you could be held in contempt of court and sentenced to jail for up to 6 months, or a fine, or both. And so you're going to have counsel. So perhaps the best move at this point is nothing's going to happen today. We're going to reset this till June 12th. You're going to have an attorney that you can speak with. And these would be great questions to ask that attorney and to advise you along the way. They're going to be advising you as to the issue before them. They're going to be appointed for the sole purpose of the motion for contempt. They're not going to be appointed to be your legal representatives for ownership issues, for title issues, for anything else. They're going to be just strictly appointed for purposes to represent you in the city's motion for contempt, and that's it. But I would recommend at this time that you do not have any more to say about your factual undertakings at the property, and let's give it time and get an attorney involved that's going to be appointed to you. And that way you can be fully apprised of your rights, and you know the risks, the rewards, the consequences when you come back on June 12th. I think that's the right thing to do. Hang on, Mr. Harper. Mr. Donaldson.
Listen to this, and I think the biggest issue here of all, whether concern is not working, they plan to work on the road and get permits and do that. The biggest issue is they were gonna hold a prayer meeting, not in the building, an activity that doesn't require a permit in the parking lot, a fundraiser outside the structure. And the city is saying, you can't do that either. That's, I think, the biggest.
So Mr. Donaldson, are you now telling me what they're going to do?
No.
Because that's no different than them standing up and telling me what they're going to do. So you need to be careful about what you say that could be used on the record to cross-examine Ms. Harbor and Mr. Harbor. What if they get on the stand and say, oh no, we never intended to do that? You're going to be called to impeach them. So
On the city's motion, they're alleging that prayer meeting, planned prayer meeting is a violation. That's why they need an emergency. I'm sorry, what was it? The city, I don't know exactly, the city, that's their main contention is that planned prayer meeting is a violation. What I'm understanding from you is the building, get it occupied, it has nothing to do with the parking lot. That's clarification we need. That's all we need. I'm sorry. That's all we need.
Mr. Eisen, I'm sorry, I may have skipped over you. I told you I was going to recognize you and I may have lost track. I'm sorry, sir. Go ahead.
You've got 3 individuals now. Charged, and this court has what's what the court calls a compliance. That's what the federal works. Now, there were some rulings made there that may clarify some things that may not have been included. But in any event, if any parties rely on that, I wonder for expedition purposes, if they don't have counsel here, or the order that transcript there. That February 21st, there are images. And yesterday, the refusal hearing, which I attended on the audio, video, comments made that your orders are now orally from the bench, the same thing as somebody, that's what the city or call for it, it's the same thing as the order. So in fairness to everybody, including the board, nobody has 100% memory. I would suggest that
All right, Mr. Eisen, I'll consider that. City, do you want to be heard on anything?
Yes, Your Honor, I guess on 2 issues. Again, not to get into the meat and merit of the motion to compel, but the May 30th postings that there was going to be some sort of function. Honestly, we did not know whether that was intended to occur on the property or not. But the way that we read the injunction is that it applies to the whole 4.808 acre tract, and that a gathering gathering for a purpose not expressly allowed in the injunction. The city believes that would be a violation. So that's one thing that we have brought forward. And I believe there is already evidence on the record from the previous hearings that there was possibly asbestos containing waste disposed of outside the physical bounds of the building, and that's one of the health and safety concerns the city had. The second issue, Your Honor, is during the break, I spoke with one of the representatives of the Canton Police Department in regards to the email that Defendant Donaldson is to give to the city. The city's
Hey, Mr. Ritter, I'm going to ask you, just grab that microphone.
Oh, I'm sorry. The city's request would be in order to give a single point of contact for the city of Canton Police Department, and also to give the city enough notice and staffing to be able to be present at the property. What we would request is that notice be given 4 hours prior to Mr. Donaldson or another New Beginnings representative visiting the property to retrieve that personal property, and that would be done within the hours of 8 a.m. to 8 p.m. And in order to facilitate that, we would provide the email address of Sergeant King of the Canton PG, which is M as in Michael, King, K-I-N-G, at cantontx.gov. And that's what we requested, that there be a 4-hour window. If Sergeant King is not on duty that day, he will sign it or give that to a shift officer who will then be able to monitor the situation out of the building. And we would further ask that Mr. Donaldson does not visit without receiving confirmation through that same email address. And that would then be one single point of contact with the city.
Repeat that second part, that he not visit what?
Not visit prior to receiving confirmation from the city and acknowledgement that we received that email.
So you're asking that Mr. Donaldson give 4-hour notice before he intends to arrive at the property to retrieve personal property?
Correct.
Was that a two-part? What was the first?
Between the hours of 8 a.m. and 8 p.m. and that email will be sent specifically to Sergeant Canton at the email address that we can provide.
Mr. Donaldson, do you have any problem with that?
I don't have any problem with that, Your Honor, but it just sounds like they have control of the property now, and that the current owner invited me up to help them or do anything else, I'll have to have permission from the sergeant to visit the property.
What would the current owners be inviting you up to help with, other than moving you're asking the court to allow you to move your personal property?
Yes, sir.
Okay.
I'm a volunteer, I'm a laborer, I'm a minister, and I work with a number of your people here who continue to call me down and ask me for help. Once this COVID virus is over with, I'm going to be physically present at the facility in Henderson. And we're going to be working with this place, and we'll probably be sending people like us until they get up in here.
So are you telling me that if the new owners, let's just call them the new owners, because that's unclear to the court, the new owners are going to call you to come work on the property according to a permit? That's your concern?
If they get a property, I'm a volunteer laborer, I go wherever God calls me, and do whatever needs to be done.
City, what would be your response to Mr. Donaldson? He's saying that he feels like that would abridge his right to visit the property for a non-personal property moving venture.
I guess the city's position would be as long as his other activities are consistent with the terms of the injunction. For example, if he's helping to mow the exterior, that would be permissible. However, anything with the interior of the property, we would request that complies with the court's order to contact the police department and notice for specifically the interior of the property.
Ms. Harper?
So can you clarify that? It is a constitutional right to be able to pray and speak freedom of speech and religion, and to be restrained from that regardless of where it's at, is absolutely absurd. And so
Are you asking me to clarify, or are you telling me how you feel?
clarification,
Okay, yes, then
you're allowed to pray.
the court's clarification of property and the temporary injunction is the building and all surrounding property.
So you're telling me that I cannot stand on private property and pray on grass on private property? It goes against the constitutional First Amendment rights.
I'm not telling you that. I'm telling you that the clarification is that property as described in the court's temporary injunction includes what it says, the physical building and the acreage outlined therein.
And that's how that's telling them can't be even do that.
Have you read this injunction? I think you need to read this injunction before you jump to conclusions about what you can, what you can't do, and what you believe I'm telling you you can and can't do.
But that's what their motion to order was for. That's where most of this came from as well. And I know there's other things, and I'm not, but that I need clarification on from you.
My clarification is that the property encompasses the building and the land for purposes of this temporary injunction. And what you should do, speak with your attorney about what you want to do. Ms. Harper, it's no different than anyone else who wants to do something. And they have a question about the law. They hire an attorney, they seek out an attorney, and they tell them, this is what I want to do. Is this going to violate an order or a law? That's what lawyers do. I know. And I'm not a lawyer that in my capacity that I can tell you. I'm a judge. I'm presiding over a case. And I've issued an order in this injunction, and the property is described as the building and the acreage. And this injunction says what you can and you can't do. And it doesn't include, Ms. Harper, I believe you're incorrect. I believe you're incorrect.
The Bill of Rights, the Constitution, you're going against that.
I believe that you're incorrect. I believe that you are viewing the temporary injunction in a different light than the court. And I believe that you should get it and you should speak to an attorney. Anyone else?
I just want to briefly respond. The city's, it was just characterized that the city's primary motivation in bringing this motion to compel was the May 30th contemplated prayer meeting. I wanted to correct that. The city, and again, without getting into the evidence, this was prompted on an emergency basis, partially by that May 30th event, which the city didn't know what the scope of it was, didn't know the location, what was concerned. But what really prompted this, and the primary thrust of the city's motion, was what the city perceives as ongoing violations of the temporary injunction that were worsening to the point where we determined that emergency relief was what was needed. And so the primary focus was not the May 30th. That was really a factor that expedited the city's hearing. The primary thrust was, we believe, the injunction was being violated and had been prior to that.
Understand. We have time. Anyone else? Any other discussion before we adjourn and reconvene on June 12th? Yes, Mr. Donaldson. So Mr. Donaldson, you're conceding to Mr. Eisen? Go ahead, Mr. Eisen. And I'm sorry, I couldn't hear that last part. I heard in rem. It's okay. It's okay.
They filed new pleadings that raised interim jurisdiction, which they had raised in the previous petition. I'm concerned, I don't know what you ran information on the hearing, but I don't know what they're gonna do with restraining orders or injunctions on that new petition. I don't want to back the case. I'm gonna probably get my motion withdrawn in here. But I hate to see a bunch of multiple hearings, we schedule that. Well, I'm gonna be up here and be in here, and we're gonna be here the next day, or get it all done at once, whatever. They have an application for restraining order on that petition. So far, they haven't made the application. And I said the injunction.
Yeah, and I don't believe that the court has seen that yet. But in regards to your motion to withdraw, I believe that we could hear that, we could schedule that quickly before the June 12th. And we can do that, as I said before, on video conferencing.
That would be fine. I mean, this comes, I didn't see, follow up the chat, and this will occur. I already know.
Okay.
There's now a dispute over the property right now in the city. Dispute over the property and results in fines and damage and all kinds of stuff. But which happens with social. Which I know is all platform and legal injunction. I mean, I've been part of the injunction, maybe somewhere, you're not on the for other issues.
Thank you, Mr. Eisen. All right, then. Mr. Harbor, if you will stay behind after court's adjourned, then I'm going to provide you with some information on the attorneys I'm going to appoint to each one of you. I'm going to give you that. And then bailiff, if you will. I need to correct something I said to you, Mr. Donaldson, earlier. I told you your attorney was Kurt Knoll, and that's correct. I misspelled his last name. It's actually just Noell. I'm going to provide you a copy of his contact information, including his email, so that you can be assured to have that. Mr. Knoll will not know about his appointment until I have time to draft the order and provide it to him. So if you contact him before I get a hold of him, you can let him know it's coming, okay? And the bailiff will provide you with that. All right, if there's nothing further, then court's going to adjourn the hearing, and this is the oral notice to be back here in this court at 9 a.m. on June 12th. And if Mr. Eisen files a motion to withdraw, you'll all be noticed. At least Mr. Donaldson will be noticed, and the city will be noticed on that, and we'll set that up as a Zoom hearing, and you'll be able to stay in your place of abode to do that. Okay. All right, this case is adjourned.